The Judiciary Staff Union of Nigeria has condemned the recent removal of the Chief Judge of Benue State for allegedly inciting the ongoing strike by judiciary workers in the state. A statement signed by the national president of the union described the action of the Benue State House of Assembly as a direct attack on judicial independence and an affront to the rule of law. In the related development, the Senate on Thursday joined in the condemnation of what it described as unacceptable removal of the chief judge, holding that the Benue lawmakers carried out the action without having recourse to the tenets of the law. We're now being joined by Maxwell Okpara, a lawyer, to discuss the controversy being generated by this act of removal and whether or not the action of the lawmakers was in sync with the constitutional legal process. Good to have you on Newsday.
Good afternoon, Vimbai. Good afternoon, Cynthia. It's my pleasure to be here.
We're glad to have you as well. Now, was this action in line with the provisions of the Constitution?
Well, I have been following this event. As a lawyer, I am expected to go in line with the Constitution. I think the fundamental question, legal issue, that one is expected to review is whether the Benue State House of Assembly have the constitutional right to pass resolution and made recommendation that the CJ of the state should be removed as a result of misconduct. Whether they have the right to make recommendation directing the executive to send petition to NJC for discipline. Then another thing is that whether the governor has the right, constitutional right, to remove the CJ, not the judge, the CJ. Remember that under the Constitution, that the same section 292 talked about how the judge, a judicial officer, should be removed and how the CJ should be removed. Now, if you watch that section 292, sub 1, paragraph A, it stated that the State House of Assembly can make a recommendation and address to the governor, recommend to the governor that the governor can remove the CJ for misconduct. It is there in the Constitution. Now, based in all the recommendations sent to the governor has written a letter to the NJC in respect of the misconduct which the State House of Assembly investigated. On the issue of removal, I asked question. I tried to make an inquiry whether the governor has removed the CJ. Governor has not done anything in respect to that. So that is all I can say.
All right. Well, in their rebuttal, of course, the State House Assembly have come and said that the flurry of responses coming from especially the Nigerian Bar Association have taken them out of context because they feel the Nigerian Bar Association is quoting sections 153 and 271, which have no connection with the issue on the ground. What do you make of this flurry of legal back and forth that is currently playing out? A lot of legal jargon happening as well. But when we unpack all of it, where can we get what's more in line with the Constitution?
Well, Section 153 and 271 of the Constitution deals with discipline of judicial officer generally. That is all the judges. Judicial officers, those that fall in category of judicial officers. But Section 292, sub 1, paragraph I talks about removal of CJ, Chief Judge. Now, if you watch the same Section 292, sub 1, also talks about, paragraph I talks about judicial officer, that is judges. Now, the State House of Assembly did not pass a resolution that the governor should remove Honorable Justice Morris as a judge. No. Rather, they passed a resolution that recommended that he should be removed as chief judge, not as a judge. These are two issues that we need to resolve. What the section 153 and 271 talks about is discipline of the judicial officers and establishments of NJC. I don't know whether you are getting what I'm saying. If you read that section, I don't know whether you can permit me to read that section 291, 292, sub 1. It said, a judicial officer shall not be removed from his office or appointment before his age of retirement, except in the following circumstances. Now, in case of, that is II now, that's the one in issue. In case of chief judge of a state, grand cadi of Sharia Court of Appeal, or President Customary Court of Appeal of a state, by the governor acting on address supported by 2/3 majority of the State House of Assembly, of the State House of Assembly, praying that he be removed for his inability to discharge his function. He's talking about the chief judge now, functions of his office or appointment, whether arising from infirmity of mind or body, or for misconduct or contravention of the code of conduct, referring to the chief judge. But what we are saying in effect is that the governor has sent a petition to the NJC, and he has not even said anything about the removal of the CJ. So I think making a noise about it is uncalled for. Let's watch what the governor will do. When we get to the bridge, we'll cross it.
No, of course, I can definitely see
that. But the Constitution gave him the power. But the Constitution gave him the power anyway. Okay. Going by the recommendation and support to total majority of the State House of Assembly.
All right, thank you for clearing that up.